Now, there is another perspective from which one can measure the role of Islamic finance in economic development, and that is from the internal perspective of Islamic finance itself. In other words, the success or failure of Islamic finance as an Islamic activity can fairly be judged by the standards that it set out for itself in justifying itself. This avoids some of the knotty definitional problems alluded to earlier. When we compare the performance of Islamic banks relative to the Islamic ideological arguments given in their support, we gain the added benefit of incorporating local views of what constitutes economic development, a perspective that ought to be invaluable in formulating policy designed to improve economic performance. It would not be unfair or extreme to describe the origins of Islamic finance as lying in a larger project of anti-colonialist resistance that sought to develop a universalist critique of imperialism and the capitalist economic system that supported it and that imperialism in turn supported. One facet of the Muslim critique of imperialism was economic, and engaged the idea, and engendered the idea of a quote-unquote Islamic economics. Islamic economics sought to develop an understanding of economic behavior informed by Islamic principles that would provide an alternative both to capitalist and communist modes of production. From the beginning, however, a certain tension existed between the universalist elements of this Muslim critique of imperialism and its particularistic Islamic elements. Accordingly, while Islamic economics decried the injustices of interest-based debt financing, and to a lesser extent the excesses of collectivization, it also seemed to accord a tacit legitimacy to the historical rules of Islamic commercial law. The historical rules of Islamic commercial law, with some important modifications, were destined, after the oil shock of the early 1970s, to become the focus of the commercial development of the modern Islamic financial sector. The more revolutionary ideas of Islamic economics in terms of a greater egalitarian society would be forgotten by the commercial development of Islamic finance, as we shall see. In any case, Islamic economists believed that it was possible to design an economic system that would eliminate the worst excesses of capitalism, which to them was manifested in the interest-based financial system, while at the same time preserving a market economy that protected individual property rights by developing equitable institutions for risk sharing. The key to developing a more equitable economic system was believed to be in the promotion of equity investment in lieu of debt investment. The Islamic critique of debt investment was that it unfairly privileged financial capital over entrepreneurial skill and labor, on the theory that, unlike an entrepreneur, a creditor was guaranteed a return without undertaking any substantial risk that would justify that return. In other words, Islamic critiques of debt investments were driven by the asymmetric structure of payoffs inherent in debt-based investment. They believed that equity-based investment was superior because it would promote a sharing of risks and rewards, with the result that wealth would be distributed more equitably throughout society. It would also force capital to share the risks inherent in productive enterprises, thus forcing capital to bear its share of the costs of failure instead of putting them exclusively on entrepreneurs and labor. They also believed that prohibiting debt-based investment would enhance allocative efficiency. Investors would only invest after taking into account the possibility that they would have to share the downside risk of any project. Therefore, they would internalize that cost in their decision-making, whereas creditors, they believe, would be more likely to finance money-losing projects since they were protected on the downside. In hindsight, of course, the belief that replacing debt-based investment with equity-based investment, while otherwise preserving the privileges of privately owned capital, would be enough to usher in a just economic order proved to be naive. Private capital, it turned out, could simply refuse to invest on the terms that Islamic economists thought were socially optimal. Moreover, problems such as information asymmetry proved that equity investment could not be an optimal structure in all cases, a lesson that Islamic banks learned quickly after they began their operations in the mid-70s. Moreover, and this would prove crucial, Islamic law itself did not provide a systematic prohibition against debt-based investment. Thus, while Islamic economists were preaching, and continue to preach to this day, the superiority of equity-based investment over debt-based investing, Islamic banks explored a new strategy, mimicking conventional banking products using the tools provided by traditional Islamic commercial law. Historical Islamic commercial law provided a variety of debt-based contracts that could be used to synthesize the economic returns from a conventional interest-bearing loan, specifically a credit sale, in Arabic, al-bay' bi-thamanin ajil, the trust sale, bay' al-murabaha, the forward sale, bay' al-salam, and the lease, al-ijara. With minor modifications of historical doctrine, primarily with regard to the non-binding nature of promises, Islamic banks discovered that they could use these well-established contractual devices to circumvent the prohibition against interest-bearing loans by entering into 2 transactions instead of 1. The basic idea was simple. Whereas in a conventional financing arrangement, the borrower would borrow funds from the bank against which the borrower would promise to pay principal plus interest, and then the borrower would use those funds to make an investment for its business, for example, purchasing machinery for its factory or paying salaries. The Islamic bank would simply reverse the order of these transactions. When the customer asks for funds, the Islamic bank basically asks it, what for? As long as the purpose is Islamically permissible, they're not financing production of wine, for example, the Islamic bank will go out and procure the item that the customer desires to acquire for its business, a piece of machinery. And then the Islamic bank will sell it to the customer on credit at a markup to the item's cash price, using an implicit interest rate that would be the equivalent of that charged by a conventional bank on the loan of the funds. In this way, the Islamic bank can maintain that it does not make money by lending it, but rather by selling assets, even though in reality its business is not buying and selling assets as such, but rather providing financial intermediation by acquiring specific items on behalf of their ultimate end users for a fee. The same strategy of replicating conventional financial instruments using pre-modern Islamic contractual form began to give rise to ever more complex contractual structures, including those underlying the so-called sukuk, commonly referred to as Islamic bonds. Islamic bonds, despite their various names and structures, all involve the following steps. The creation of a special purpose vehicle that is owned by the economic borrower, a contract between the parent and the special purpose vehicle that transfers certain assets to the SPV, the special purpose vehicle, which are then held in trust for the benefit of investors, a contractual commitment of one sort or the other between the special purpose vehicle and its parent that generates a series of cash flows in favor of the special purpose vehicle, for example, a lease. And then finally, the sale of investor certificates from the special purpose vehicle to investors, giving the investors a right to the cash generated by those assets that are held in trust for the benefit of the investors. And then finally, to close the loop, an undertaking from the parent or an affiliate of the parent that it will repurchase the assets of the trust for a price equal to the par value of the investor certificates at a predetermined date in the future. Now, recently, this repurchase undertaking became subject to financial headlines when it was unclear whether the sukuk issued by the Dubai-based realty company Nakheel would be redeemed pursuant to its parent's repurchase undertaking. That was the big issue on whether or not the Nakheel bonds would default, if anybody was following that story. Through these various steps, issuers could recreate the economics of conventional bond investment, albeit using a much more complex structure. The fact that such interest instruments were deemed to be Islamically compliant gave issuers the added advantage that by structuring these bonds Islamically, they could access both the Islamic and conventional investing market, a fact that helps explain the phenomenal growth of the sector in the last decade.